The California Association of Realtors has now licensed C.A.R forms to .loop. A super cool texting feature and mobile app lets you share documents, edit, and e-sign on the go. So start smiling, California. Your complete solution is here.
Get ready, everyone, to take notes. Our next session is a very important topic and is a reimagined fan favorite. You won't want to miss this. Gov. Hutchinson, Assistant General Counsel to C.A.R., is here to give you the inside scoop on the biggest legal topics you need to know to keep yourself out of trouble. Take it away, Gov.
All right, everybody. Hello there. Welcome. I am Gov. Hutchinson, your attorney. I'm in charge of the legal hotline. And you know, on the legal hotline, we get 400 calls a day on all sorts of things. And I want to talk about, just for a little while today, some of the hot topics we've been getting this year and right now, things you really need to know as an agent. Obviously, I'm going to talk about COVID stuff, but not just COVID stuff, but there's a lot going on out there that you need to know. Let's start with the COVID rules. That's still the #1 questions we get. We're still under the rules. We're still under the governor's stay-at-home order. We're still under the guidance from the California Department of Public Health. Realtors, you're allowed to work, but you can't do everything the way you've always done it. This is going to change. Things will loosen up soon, but right now we got to follow the rules. You know the basic rules. You can't do open houses. You can't do normal open houses. Everything is by appointment only. Just limited to one buying party at a time. You have to treat open houses like a showings, which I'll talk about those rules in a second. By the way, I should say right up front, if you have questions on anything I'm talking about, you can put them in the chat. And one of my colleagues, Amanda Bion, will be there answering your questions. Sometimes she may even send it to me and I'll answer it live. And of course, if you have any questions that I don't get to today, call the legal hotline. Anyway, okay, so showing rules. You know what else you can't do? You can't go around door knocking. You know what else you can't do according to the Department of Real Estate? You can't leave flyers off. You can't just walk through neighborhoods and leave paper flyers in people's flyer boxes. You try to be as virtual as you can right now. What about when you're showing properties? Well, remember, if you're visiting the property, whether you're a buyer, a buyer's agent, an inspector, an appraiser, a stager, I don't care who you are, when you're going to someone's property, you have to submit a PEAD form, the P-E-A-D-V for visitor. Must be submitted in advance to the listing agent. Listing agent, you got to keep these in your file for at least 3 years. Remember on the PEAD form, buyers and agents, you got to submit one every time you visit. And you should put the address of the property you're visiting when you do it. And you should also, send the PEAD as close as possible to when you're going to go to the property. If you're going to go in the afternoon, send it in the morning. Send it as soon as possible, because remember, this PEAD form, you're declaring your health situation, and your health situation can change. So please do that. On the listing side, on the house side, the people who live at the property, the occupant of the property, should submit a form called the PEAD-S for seller. Whether it's a seller or a tenant who lives there, they also submit a PEAD form to the listing agent. Do they have to do it every day? No, just do it once and then update it if anything changes. So you got the PEAD form. The other important form, of course, is the PRE, the Posted Rules of Entry. Listing agent, during the showing, you must post this document. It has little pictograms on it. You must post it near the entrance to the property during the showing. So those are the two important forms, the PEAD form and the PRE. And the listing agent, you must also send the PRE form to the MLS electronically, okay? So the PEAD forms, the PRE forms, they haven't changed. Now on this PEAD form and on this PRE form, they tell you what the rules are. What are the rules for showing? Well, first of all, if you're the visitor, what are your rules? Well, you gotta wear a mask. You gotta disinfect your hands before you go inside. Once you're in there, don't touch anything, right? stand 6 feet apart at least from everyone who else is in there, other than the people you actually live with, of course. And remember, it should be only one buying party at a time. Now, some places, there's some counties and cities in this state which are even stricter than that, and they only allow 2 buyers and 1 agent at a time. So if you're in one of those areas, you got to follow the local rules. If you don't have local rules, you got to follow the state rules. Remember the state rule, 1 buying party at a time. Don't touch, stand 6 feet apart, wear the gloves, wash your hands. Now, what are the rules on the house side? Well, somebody has to show up before the showing to make sure that it's ready for the showing. What does that mean? Well, that means when the buyer shows up, there's extra masks, there's extra hand sanitizer if they didn't bring their own. You have to prepare the house. You got to make sure all the doors are open, all the lights are turned on. You have to make sure, weather permitting, fire permitting, that there's at least 1 window open for ventilation. And then you have to clean the property clean the house before the showing. You got to wipe down surfaces, banisters, handrails, light switches, doorknobs, countertops, sinks, and even the toilet. You got to clean it before and after each showing. Well, now you're going to say, whose responsibility is it to do all this stuff? Is it the seller? Is it the listing agent? Is it the buyer's agent? You know whose responsibility it is? It's the showing agent. That's usually the buyer's agent, but it could theoretically be the listing agent if there's no buyer's agent showing the property. Maybe the listing agent's showing it. Who's ever showing it, it is your responsibility to meet all these protocols, the cleaning, the opening the doors, the cleaning, the light switches and all that stuff, making sure they're masked there. That's the showing agent's responsibility. Now, of course, you can agree with the seller. The seller can say, no, I'll take responsibility to do that, in which case you make sure you get that in writing from the seller that they're going to do it. Okay? So those are the basic rules. They haven't changed much recently. They're probably going to loosen up sometime soon as we open up. But right now, you still got to follow those rules. No open houses. Don't do door knocking. Don't drop off flyers. Hang in there. You can use the mail. You can do things virtually. And you can still show properties if you follow the rules. You got to do this not only to keep everyone safe, but because you don't want to get in trouble. You don't want to get sued. Sellers have hidden cameras. They'll see what's going on. The Department of Public Health, the DRE is starting to get involved. And of course, it's actually a misdemeanor. It's a criminal offense to violate these rules. Okay? All right, so that's one big topic we get a lot of. Another big topic we're getting right now is throughout California, it's pretty much a hot market. There are a lot of offers. Sometimes there's a lot of multiple offers. We get a lot of questions about how to handle that. Certain things you got to remember, of course. I mean, if you're a listing agent and you get several offers and you want to counter all of them or more than one, can you do that? Yeah, but you got to use the right form. You got to use the seller multiple counteroffer form, not the regular seller counteroffer. The SMCO, not the SCO. What about on the buyer's side? If the property's already pending, it's already in escrow, can I submit a backup offer? Sure, if the listing agent's going to take backup offers, and there's a form for that too. The backup offer addendum, BUO. You know what else we're seeing? We're seeing a lot of buyer's agents. They know they're in a competitive situation. They're competing with other people, so they're trying to get creative on their offers. It's good to be creative, but you got to be careful about some of the things. Sometimes we see offers where they say the offer is the deposit is non-refundable. Can you have a non-refundable deposit? Well, actually, there's a court case that says to do anything like that, it's got to comply with the California law regarding liquidated damages. And you've already got a liquidated damages clause in the purchase contract. So you can't really just say, buyer says, deposits non-refundable, will be released immediately, you never have to give it back. Even if the buyer says that, even if the seller agrees to that, courts aren't necessarily going to enforce that unless it separately complies with the liquidated damages law, and you've already got a liquidated damages clause. So you really would need an attorney to draft that. It's complicated. I recommend not trying to do that. You know what else we see? Escalation clauses, sharp bids. My offer is $10,000 more than the next best offer you get. Is that legal? Sure it is. Got to be careful though, right? What do you put in an offer $10,000 off the next best offer and somebody else offers $200,000 over the fair market value? Your offer is now $200,000 plus 10 over the fair market value. And you may not want that. You might want to put a cap on your offer if you're going to use an escalation clause. What if the seller gets two different offers? They get more than one offer saying, my offer is 10,000 or 5,000 better than the next best offer you get. You know what? Those two offers are basically going to cancel themselves out. Court's going to say there's no way that that can work, so they probably just won't enforce those offers at all. You see what I'm saying? You got to be careful when you do this. Think about these things. You know what else we see? Sometimes we see offers where they say, my offer is the appraised value plus 10%. But the problem is, what does that mean? Does that mean whose appraisal? What if there's more than one appraisal? Is the buyer's appraisal, lender's appraisal? Does that mean if the seller accepts that and the appraisal comes in low, the seller is required to reduce their price to the appraised value? We've had people call the hotline and they write the offer that way, and then they ask us, what does that mean? And we say, you wrote the offer. What do you think it means? The problem is nobody knows what it means. We would always recommend, if the buyer wants to get that creative, the buyer should get their own attorney to help draft an addendum, sort of explaining and being very clear what that language means, what are all the possible consequences. I've seen attorneys do this, and it's like a 1 or 2 page addendum. So you can't just write whatever you want in the offer without thinking about what does it really mean and what is the really impact. You know, another thing you got to think about, what if I'm working with one buyer and I'm submitting several offers at the same time on several different listings? Can I do that? Yes. But did you know there was another court case that said you have to disclose to the seller if you've already made another offer on another listing at the same time and you only intend to buy one of them, right? So that's an issue that can come up sometimes. We also see where people make non-contingent offers. You know what that means, right? You're saying, I'm going to buy this property no matter what. Even if I do an inspection, I don't like the inspection, too bad for me. If I don't get the loan, too bad for me. If it doesn't appraise, too bad for me. So you have to be very careful and know what you're doing when you make a non-contingent offer, because that means once you're in escrow, if you can't buy it, you're probably going to lose your deposit. The seller probably is going to cancel you. You know what else we're seeing? We're seeing appraisals taking a long time. And we're seeing appraisals, not only are they taking a long time, but they sometimes come in low. You got to think about that when you write your offer, right? I mean, what if the appraisal comes in low? What if it doesn't appraise at all? You know, what if it's just too late? Well, buyer, if you don't have a contingency, you don't have an excuse, and you're probably going to lose your deposit. You have to think about that. By the way, if I remove all my contingencies, does the buyer still have the right to cancel in certain circumstances? Well, even though you've removed your contingencies, the buyer still has a 5-day right of rescission after receiving the transfer disclosure statement or the natural hazard disclosure report or the lead paint form. Is there any way so the buyer does not have that 5-day right of rescission? Yes. Listing agent, if you make sure the buyer gets those documents and the buyer signs those documents before they sign the offer, they don't even have the 5-day right of rescission. But if the buyer doesn't sign those 3 documents prior to signing the offer, they still have a 5-day right to cancel starting on the day their agent receives these forms, even if they've removed their contingencies. So you have to keep that in mind when if you're on the seller side. If you give the buyer all the disclosures and make them sign them before they sign the offer and there are no contingencies, then the buyer doesn't really have a way out of the deal. And if they don't perform, they might lose their deposit on the liquidated damages. We see buyers who want to make their offer contingent on selling their house first. You can do that, but make sure you use the form, the contingent on purchase or sale of another property, the COP. Sometimes sellers now, right? They want to sell, but it's so hard to find a new house. They want to accept their offer contingent on finding a replacement property. Can they do that? Yes. But there's a form they got to use for that called the SPRP. Okay, seller purchase of replacement property. We got forms to handle these things, but you have to use them, okay? Another thing we see sometimes are, can sellers say, I'm not even gonna let you see the property unless you submit a pre-approval? Can they say you can't even see it before you submit an offer? They can, as long as they treat everyone equally. They can't give preference to certain people, but in general, yes, sellers can do that. Key things to remember, of course, are order appraisals early. Another thing you really need to do is check out the fire insurance. Order that early, because it may take a while, and sometimes you're going to find out that you don't get fire insurance from the fire insurance company, and you have to rely on the FAIR plan, the California Fallback FAIR plan, which is maybe going to cost you more than you thought. So order the appraisals early, order the fire, and try to get the fire insurance early, use the right form, be careful using these escalation clauses and these appraised value plus. Make sure, be careful about non-refundable deposits. One more thing. What if I'm in a fire area and there's a fire during escrow? Can I cancel the escrow? Well, it depends. If the house that's in escrow burns down or gets damaged, probably. But what if there's a bunch of fire in the neighborhood, but the house I'm actually in escrow to buy is still there? Can I get out of the deal because the neighborhood has changed? Well, that's going to be up to a judge. The court's going to have to decide, is that a really material change to the entire transaction? Or is it not material, it's not significant enough? We don't know. It depends on the circumstances, okay? All right, another thing to be careful about are sellers renting back. If the seller's going to stay beyond close of escrow, we recommend you use a form called the SIP, the seller in possession form. Don't just let them rent back without some type of rental agreement, okay? It's always good to do that, because then you can put some type of penalty if they don't leave on time. And you probably don't want them to stay more than 30 days, because once it's beyond 30 days, it's no longer a short-term rental. And then we got to think about all the new rules on evictions. Well, let's talk about the new rules on evictions. By the way, what I'm about to tell you is very complicated stuff, and you probably shouldn't be explaining this to your clients. When your clients ask you, what are my rights as a landlord to evict this tenant or not evict this tenant, you should probably say, no, you should definitely say, you need to talk to a California real estate attorney. I'm telling you, though, because some of you might be landlords, or some of you might be property managers, or some of you might be tenants. So what is it that you need to know right now? Well, here's the deal. We're in a situation now where the California legislature passed a law that said there's an 11-month period from March 1st, 2020 to February 1st, 2021. During those 11 months, you cannot evict someone for non-payment of rent on residential property if the reason they're not paying is because of COVID. In other words, if they submit a COVID declaration of COVID financial distress, if they submit that form, you, the landlord, cannot evict them for not paying that rent. Does that mean they don't have to pay me eventually? No, they have to pay you. They owe you the money, but you just can't evict them for not paying it. And there's two periods. There's what we call the protected period. That's March, April, May, June, July, August. For those 6 months, tenants didn't have to pay any rent if they have a COVID reason. Starting September 1st, September, October, November, December, January, for those 5 months, they still got to pay 25% of the rent, even if they have a COVID reason. So if my tenant in October doesn't pay any rent at all, they don't even pay the 25%, can I evict them? Yes, but not until February. They have until February to pay that 25%. Can I evict them in February? Yeah, if they didn't. What if they did pay the 25%? Can I evict them for not paying the extra 75%? No. What about the tenants who didn't pay their rent March, April, May, June, July, August? Can I evict them for not paying that rent? No. But you can sue them for the money. When can I sue them? You can sue them right now. You could go to Superior Court and sue them. Or you could go to small claims court and sue them for less than $10,000. And starting on March 1st of next year, you can actually sue them in small claims court for more than $10,000 for the back rent that they didn't pay because of COVID. What if a tenant's right now not paying the rent, but they don't have a COVID reason? Well, you can evict them right now. Well, what if I'm a landlord right now and I'm not sure my tenant, they're not paying rent, and I don't know if it's COVID or not. Can I give them a 3-day notice to pay rent or quit? Not for the next 4 months. For the next 4 months, you got to send them a 15-day notice to pay rent or quit. It's called the PRQ CPP for the protected period, the PRQ pay rent or quit, TP for transition period. In other words, if they owe you money from March to September 1st, and you want to send them this notice, 15-day notice, you send them the notice to pay COVID protected period rent, the PRQ. If they owe you money after September 1st, you send them the other 15-day notice. And by the way, 15 days, you don't count weekends and holidays. You're giving them 15 days to respond to you with the declaration of COVID financial distress. If they respond to you with that form, you can't do anything to them. You can't evict them. You can never evict them for not paying that money. Although after September, they have to pay the 25%, right? So if they're behind on the rent after September, you send them the other form, they notice to pay COVID transition period rent. Of course, some of your tenants are going to owe you money before September and after September. So you're going to send them 2 different 15-day notices. What if the tenant owes you money, but it's not rent? They owe utilities, they owe late fees, they owe, one of their check bounce, they owe you the bounce check charge, or they need to replenish their security deposit. If you want that money, you got to send them a separate 15-day notice and to cure a monetary covenant. And there's one for pre-September and then one's for after September. So there's 4 15-day notice forms, pay or quit notice forms that are replacing the normal 3-day notice forms for the next 4 months. After February 1st, we go back to the regular 3-day notice. What if the tenant owes you rent before March 1st of this year, but you didn't get around to evicting them, and now you want to evict them? Can I send them a 3-day notice for the pre-March 1st rent? You could. You can evict them for that. And come February 1st of next year, you'll be able to evict them. Okay? So 4 15-day notice forms are replacing 1 3-day notice to pay or quit. Okay? There's another form, and then there's the declaration form that comes attached to these forms. So when you send these forms to the tenant, the declaration is attached, and they have 15 days to return it. What if I send the tenant the 15-day notice to pay rent or quit, and they don't return the declaration in 15 days? Well, now you can proceed with an eviction right now. If they do return it, remember what I said, you can never evict them for that money, but you can sue them for the rent. Okay? There's another form you have to send your tenants. If your tenant was behind in the rent for any time between starting March 1st, you have to send them this disclosure form telling them about their rights. It's called the NTRA, the Notice Regarding the Tenant Relief Act. You have to send them this form even if you're not planning on sending them a 15-day notice. If you are sending them a 15-day notice, you got to send this form before you send the 15-day notice. But please, all residential landlords, if your tenant was behind in the rent after March 1st, send them this form. What if they're behind, but now they're caught up? You don't have to send them the form. Okay? So far I've told you about the 4 15-day notice forms, and then there's the declaration that comes attached, and there's a whole separate form, the NTRA, that you're going to use, that you have to give them to disclose their rights. Okay? All right. We got other new forms that came out. There's a form called the Coronavirus Unpaid Rent Repayment Agreement. Maybe the tenant is going to agree to repay the rent. You have a nice form to use to set up a schedule. We got another form called the Unpaid Rent Calculation. What does that mean? Well, that's the form you're going to use it's so complicated to figure out, do they owe me this much rent for this month, and this much for this month, and this much for this month. You want to break it down and show them how much rent they owe you for each month. And you want to make sure that if they do give you money now, you're applying it to the right rent default, okay? So that's a good form to use. We even have another good form. It's called the Coronavirus Rent Forgiveness Termination of Tenancy and Possession of Premises Agreement. You know what this is? This is a fancy form for cash for keys. Maybe you're a landlord and your tenant owes you all this back rent, but you'd really just like to get them out. So you approach the tenant and say, you know what, you owe me this money. Eventually I'm going to sue you for this money, but if you leave right now, I'll forgive the debt. What do you think about that? It's a possibility, right? You can do these things. It's a possibility. What about, by the way, all of these forms are on zip form in the library for COVID forms. And all this other information I gave you, like on the rules on showing, we have a place on our website called COVID Legal Docs. If you go to C.A.R.org, it's a banner right at the top of the first page, COVID Legal Docs, or you can just go into the Transaction Center under Risk Management. But it has all these rules there, you can get them, okay? The rules for showing, the rules for evictions. Okay, what else? Well, can I evict a tenant right now if they do something else that's wrong? What if they pay their rent, but they're violating some other term? In other words, they have pets they're not supposed to, they're subletting without permission, they're doing criminal activity, they're committing waste, they're creating a nuisance, they're not allowing me to show the property. If the tenant's doing anything like that, you can evict them right now. Of course, you first have to give them a 3-day notice to cure, right? Don't use the regular 3-day notice to cure. Don't use the notice to cure or perform covenant. Don't use the regular PCQ. For the next 4 months, you're going to use a separate form, the PCQ C.A.R. So in other words, for the next 4 months, you're not going to use the normal 3-day notice to pay or quit, and you're not going to use the normal PCQ or, perform covenant or quit. I told you there's 4 different 15-day notices if they owe you money, and then there's other forms. There's a different form, to perform covenant COVID-19 Tenant Relief Act if they're doing something else wrong. But if they're doing something else wrong, you can evict them right now. Well, what about the tenant? They're not doing anything wrong. They're paying the rent, and they're not violating any other terms of the lease, but I just want them to leave. Don't I have the right to evict the tenant right now? Do I need a reason? Is there such a thing as no-fault evictions right now? Well, remember at the beginning of the year, California passed this California rent control law that said certain properties in California, you can only evict someone for just cause. You need a reason. But single-family homes were exempt. Owner-occupied duplexes were exempt. Other people that were exempt were new construction buildings less than 15 years old. Well, guess what? From now until February, nobody is exempt. If you're a residential landlord in California, you need a reason to evict. Number one, if they don't pay the rent, they don't submit a declaration, that's a reason. Number two, they violate some other term. You give them a 3-day notice to perform covenant and they don't do it. Number three, you can evict them for just cause. But the only reason you can evict someone right now for just cause for no fault is, number one, you want to move into the property, you, parent, grandparent, child, grandchild, you or your spouse. Number two, you can take the house off the rental market, but that means you can't rent it to anybody else. Number three, you can do a substantial remodel, but that only works if the remodel is necessary to make the house habitable. It's for health and safety reasons. Number four, if there's a government requirement to do it. And for all of those reasons, if you want to evict someone, you can do that, but you got to pay them 1 month's relocation cost. Now, and there's a form to do this, right? It's that normally you'd use the NTT notice to terminate tenancy. Nope, for the next 4 months, you're going to use the NTT C.A.R., the notice of termination of tenancy under the Tenant Relief Act. But there's one more reason that you can evict someone right now, which is good news for realtors. If it's a single family house and you're selling the house to a buyer who wants to occupy, Once you're in contract with that buyer, you can give the tenant 30-day notice or a 60-day notice to vacate, and you don't even have to give them a 1-month relocation fee. Of course, I'm assuming that the tenant's not on a lease. If they're on a lease, of course, you have to wait till the end of the lease. Month to month, though, you can just terminate them. Right now, single family home, you have to wait until you're in contract with the buyer who wants to occupy. Okay? All right. A couple more things to mention about this. Some of you live in cities or counties, Los Angeles, for example, that have their own local rules. They have their own local eviction rules. Well, what takes precedence? The state or the local rules? It depends. When it comes to defining what just cause is, if your city has a stricter definition of what is just cause, the city's ordinance is the one that takes precedence. What if I live in a city that says there's an eviction moratorium that goes on for another year or two? Well, then the state law supersedes that and says, no matter where you are, starting March 1st of next year, that's when the commencement period must start for the responsibility to pay back the rent. What if I live in a city that says not only is the eviction moratorium going to end later, but even once it ends, the tenant has 12 months or more than that to repay the back rent? Well, if you're in a city like that, like Los Angeles, the state law says no matter what, the limit, the last day, the deadline for paying back all the back rent is March 1st of 2022. So you see how complicated this is? It depends on what city you're in. You got to be using the right form. This is why I don't want you to be advising your clients. Another thing, and of course we do have a Q&A on this on our website that explains all this. We've done a webinar that was recorded that explains all this. This session right now is being recorded if you want to see it again, but it's complicated stuff. One more thing. Did you hear that the CDC, the federal government, has its own eviction moratorium? Did you know there's a nationwide residential eviction moratorium in the whole country? You can't evict any tenant in residential property until the end of the year if they have a COVID reason. Well, what takes precedence, the state law or the federal law? Well, generally the state law takes precedence because it's more protective of the tenant. And the federal law says if your state law is more protective, then it takes precedence. But there's a couple of things in the federal law that are more protective of tenants than the state law. Who's ultimately going to decide what law takes place? Is it federal court? No, California courts are going to decide if the federal law supersedes the state law in any cases. There are two things I want to tell you about. The federal order seems to say that if someone has a COVID reason not to pay, you can't evict them even for rent that was due before March 1st of this year. And you know what else the federal order seems to say? It seems to say that if you can't evict a residential tenant for a no-fault reason, if they have a COVID reason they can't pay the rent. So what I'm really telling you is, go ahead with your eviction, go ahead with your no-fault, go ahead with all of your evictions, but if you submit a no-fault eviction like own or move in or selling the house to a buyer who wants to live there, or if you're trying to evict someone for rent that they owed prior to March 1st, go ahead with it. But if the tenant responds with the federal declaration of COVID financial distress, I wouldn't go forward with the eviction until January 1st. One more wrinkle in this whole thing. Okay, let's talk about some other stuff. What other stuff's going on out there? What else do agents need to know about? Well, you know, there's couple of new forms, a couple of new disclosure forms. There's one you might have noticed called the Fair Housing Form, Fair Housing Discrimination Form. This is a disclosure form. It's not a required by law form. It's an advisory, but it's pre-attached to all of your listing contracts, all of your purchase contracts, all of your leases, all of your buyer broker contracts. So it's automatically there. It's part of the deal. Make your client sign it. It protects you. It protects your client. It explains fair housing. There's a lot of laws regarding fair housing. It explains what the penalties are. It explains what the DRE requirement is for education. It explains how the Code of Ethics deals with fair housing. It tells you what the resources are. And more importantly, it tells you things you shouldn't do. Not everybody knows what they should do or shouldn't do. And this form sort of helps you out. You know, there's some things that you got to be careful of doing, even though you're not intending to discriminate. It still may have the discriminatory effect, so you can't do it. For example, some landlords or sellers say, oh, I don't want to sell this house with a swimming pool to these buyers or these tenants with little kids because I'm worried about the kids drowning in the pool. It's not your call to make. It's not the seller's call to make. It's not the landlord's call to make. If you refuse to sell to those people or rent to those people, you're discriminating against families with children. Here's another one. These buyer letters, these buyer love letters. People don't mean anything bad by that, but remember, as a seller, when you're selling a property or a landlord renting property, you're supposed to be making your decision based on objective criteria. You know, if you're a seller, you're supposed to be making your decision based on the terms of the offer. Down payment, the price, the contingencies, the deposit, and objective characteristics of the buyer, such as their pre-qualification and all that stuff. You are not supposed to be making your decision based on any personal characteristics of the buyer. Personal protected classes, there are 22 of them in California. Everything from race, religion, color of skin, country of birth, age, gender, sexual orientation, family status, marital status, disability, medical condition, age, military status, source of income. Did you know you can't discriminate against someone based on what they do for a living, assuming it's a legal source? And a landlord, you can't refuse to rent to someone based on the fact that they have a government subsidy like Section 8. Getting back to the letters, when the buyer submits these letters, often in these letters, they're disclosing as part of these letters personal information about themselves. Talk about their family and their kids. Through these letters, the seller may learn their family situation, whether they're married or not, how many kids they have, how old they are, various things. And if they submit pictures, you even know more about them, maybe their ethnic background and things like that. Or that you find out what they do for a living. These are all things you're not supposed to use in your determination of whether someone, whether this is the person to take for your offer. So you see, the risk is when you submit these letters, you're putting a risk on the seller. They're increasing their risk, because what if they get the letter with the photos and they don't sell to that person, they sell to somebody else? That person's going to say, well, maybe they didn't sell to me because of my personal characteristics. Or maybe you do sell to them and somebody else whose offer you didn't take says, well, why did they take my offer rather than their offer rather than my offer? It must have been because of the personal characteristics. And if you never got the letter, you can say, I didn't know about their personal characteristics. You see what I'm saying? And of course, this form also tells you about all the things you definitely just don't do. Don't treat people differently. Show someone houses, make them tell you what they're looking for. You get the criteria, you show them houses that meet their criteria. You don't steer them to this neighborhood or that neighborhood. What if they tell you, I want to live with people I want to live in an area of people who look like me or my religion or whatever? You say, listen, I'm not going to help you with that. I don't look at it that way. You tell me where you want to see properties. You don't steer them in any way. You have to think about that. You don't refuse to show certain people. You don't refuse to, to sell to certain people. What if your seller says, I only want you to show this people to these people? Well, then you don't work with that seller. I mean, the seller could say, I only want to see offers over $1 million. That's one thing. They can have objective criteria, but otherwise, don't let the seller be the one to also tell you how you're going to, what offers you're going to present and how you're going to respond to them. You got to treat everyone the same. You understand that there's all sorts of rules. There's good examples of things you should do to avoid problems, your whole selection process. It's a good form. Please have your clients sign it. Another form that's coming out in December, there's a new disclosure form coming out in December. It's called the home hardening disclosure. The idea here is, you don't have the terrible situation we are in California with all these fires. Did you know if you're in a fire zone, if you're in a high or very high fire zone, and the property was built before January 1st, 2010, starting next year, there'll be a mandatory disclosure the seller will have to give to the buyer. It's a new form coming out in December. You know what the purpose of this form is? Starting January 1st, 2010, the building code changed. So if you lived in a fire zone, very high or high fire severity zone, and you build a house, you had to build it a certain way so it didn't have dangerous features that make it susceptible to wildfires. But if you live in a fire zone and the house was built before January 1st, 2010, the house might not have these safety features. So you're going to have to give this form to the buyer. And if the house is built before 2010, it says to the buyer, you know, you might want to think about making some improvements to your property to make it fire safe. And it even gives you a link to how to get information on how to do that. Also, the seller is going to have to disclose on this form, if their house is built before 2010, they're going to have to disclose if they have certain features of the house that make it more dangerous to fires. Like if they have a shake roof, like they have gutter covers that are combustible material, they have single pane or non-tempered glass, or they have things like that. So in other words, it's a disclosure, and it's also a questionnaire the seller has to answer. It's required next year, but it's only required if you're in a high or very high fire zone, okay? So the Fair Housing Advisory just came out. This form is coming out in December, so you can use it in January. We get a lot of questions on fire insurance. Of course, all these 15 COVID forms I told you about, they're still going to be around until February 1st at least, and who knows if these laws may get extended beyond that, right? So there's a lot going on out there. There's a lot you need to know about. Couple other things real quick you should probably know about. Be careful what you put on social media posts. You know, social media posts, it's part of your real estate criteria. Your broker could say, I don't agree with your social media posts. I don't have to let you work here. Know what else you need to know about? As an employer, as a broker, you got to make sure that if someone in your office gets COVID, there's a new requirement that you must take an effect next year. You must notify any other employee in the office who was exposed to this person within 1 business day, telling him they were exposed, what steps are you going to take to disinfect the property, and what rights are they going to have going forward? What rights are the employment rights does the employee have? Another thing, if you're a broker, do you know what? If visitors come to your office, like someone from another office or a client, and they're in your office, you got to keep track that they're there, keep a record of it, screen them when they come in for their health condition. And if they get sick later and come back and tell you, you know, I got sick, I was in your office a couple of days ago, and now I tested COVID positive, you're going to have to go back, notify everyone who came into the property after that. It's called contact tracing, but you're required to do this as the broker and notify everyone else who came into the office after that person. There's a lot going on you need to know about. It's crazy stuff, okay? We're almost done here. This was recorded. If you have questions, please call the hotline. Call me, Gov Hutchinson. I'm your lawyer. We're going to have a break now. Be sure to check the exhibit hall. You can go to the fun room and have a yoga break. Don't forget to play the hunt for a chance to win some great prizes. All the sessions are going to start up again at 1 o'clock. Okay. I have less than a minute to go. Is there anything else I want you to know? You know what else I think about? If I were, one thing to remember, if you're a broker and you have an office of at least 5 people, all managers and supervisors in the office have to take a class on workplace harassment by the end of the year. It's on the C.A.R. website. Please take the class by the end of the year. W-2 employees have to take it too. Independent contractor realtors, you don't have to take it, but I would take it if I were you to find out what the rules are. We all got to avoid workplace harassment. It's not just sexual harassment. And There you go. Okay. I think we're about to get cut off. I don't want to say anything else to get cut off mid-sentence. It's been a pleasure, everybody. Call the hotline. We'd be glad to help you.
Are we still connected? Oh.
Okay, good stuff.
I told you.
This is
Endless.
this is getting wilder by the day.
Wow.